Hello and good afternoon. My name is Charles Knight. I'll be taking the session this afternoon. We're just a minute before 1, so we'll wait till 1 o'clock, see if anyone else joins us. This is a very practically focused session, which, yeah, you get there and pitch, which builds upon something we don't often talk about in these kind of programs, which is what do you do if it all goes wrong, which can sometimes happen. Hopefully not, but occasionally it can happen. And I want to talk you through both my own practical experience and some scenarios, some real world scenarios from people about how it's all gone wrong for them. But don't worry, the session is about what to do if it goes wrong and how to avoid this. Okay, so don't worry, it's a very positive session that should help you out. So we just wait for a minute, see who else joins us, and then we'll kick off, as it were. If as we progress through, if anyone's got any questions or comments, please put them in the chat. You'll be able to add questions and comments on the chat. I must confess, these days I tend to, because of my role, spend more time in Teams than I do in Blackboard Collaborate. So if at various points I look slightly confused, it's just because I'm sometimes not great. Oh yeah, great, they're all there. I'm so used to Teams, okay? But we'll just wait a minute, see who else joins us. During lockdown, I became addicted to flavored American coffee. Flavored coffee, by the way, if anybody wants an interesting business app, flavored filter coffee is not particularly big in the United Kingdom. There's a few companies that do it, but there's not massive amounts of it. And so I've been importing flavored American coffee. Today's coffee is toasted coconut, which if you add some coconut milk to, is even more coconutty. It is. I'll have to put some pictures up. So it's interesting because in the US, there's literally hundreds of these brands. Starbucks does quite a lot, Target, Dunkin' Donuts, if anyone's familiar with Dunkin' Donuts, and so on. Okay, so let's get started. My name is, as I've mentioned, Dr. Charles Knight. I'm just going to give you a bit of an intro to my background. So I've worked in higher education for a number of years, but across all of my time in higher education and previous to working in higher education, I have done commercial private consultancy work, and it's been for a range of different companies. So I've done private consultancy work for the public sector, large government organizations, and I've done consultancy work for private organizations. And in each of those scenarios, they have not hired an organization, they've hired me as a contractor. Now, sometimes they've contracted me through a company I've owned, and sometimes, depending on their needs, they've contracted me directly. Across all of my career, generally speaking, most things have worked out fine, except the bit that nobody ever taught me about and isn't really covered in many of the books is what happens if something goes wrong, if the client is unhappy or something else goes wrong. And what I'm going to cover in this session is some common scenarios about how things can go wrong and talk you through what to do. And hopefully this is a very practical session, help you avoid some problems at the start of your self-employment and entrepreneurial careers. My other experience, which is relevant for this, is before I joined the University of Salford, I ran a productivity and innovation centre. So I would work with businesses ranging between startups to about 10 million a year in revenue, and I would help them develop new products and services. And so with those organizations as well, I'd come across many scenarios where companies could get themselves into trouble for a range of different reasons. And so what we're going to discuss in this session are some common scenarios where things go wrong and how to get yourself out of them or to avoid them. As we progress through, as I've mentioned, if you have any questions, please put them in the chat. And as we discuss the scenarios, I'm interested to see what you've got to say. Just as a disclaimer, because of some of the things I'm going to discuss, I'm just going to read this out. This presentation is intended for educational and informational purposes only. Nothing contained in this presentation could be construed as the rendering of legal advice, either generally or in connection with any specific issue or case. You should always consult with an attorney or a solicitor for legal advice as to any specific issue or case. So the reason I put that one in there is actually because after doing this kind of thing for many years, I'm trying to avoid a problem if something goes wrong later. I'm trying to avoid liability in case some of you take my advice and say, but Charles, I took your advice and it made it worse. So my disclaimer is this is for educational and informational purposes. I'm not actually giving legal advice, and indeed I am not legally qualified. I am talking from a practitioner background. By the way, it's a criminal offence in the United Kingdom to pretend to be a solicitor, so don't do it. Okay, so I want to talk about, it's really interesting, having done this session over a number of years, some of the things that I talk about in it is changed. And I'm going to mention something now that I never used to mention, but I think is really, really important for you to all understand. So the UK economy has changed in the last 10 years. Some of you may be students from the School of Arts and Media, you may be students from a nursing background, you may be business school students. One of the things that's changed in the economy over the last 10 years, you have to be really careful about if you're going to be self-employed, is there has been a growth in what we call disguised self-employment. So you're here because you want to run your own company or you're already self-employed. Something to watch out for though is, and you'll see it in one of the scenarios, there's been a real rise in attempts for people to disguise employees. And what I mean by that is you will be presented potentially with scenarios where people approach you to do work for them and they'll say to you, oh, you're self-employed. However, in reality, because of the things that you're doing for them and in the ways that you're doing them, you're not actually self-employed, you're a disguised employee. And you need to be really careful about this. And so very briefly, genuinely self-employed people provide services to clients and customers, right? You do not work for the organization. You have a contract with them to supply a product or a service, but you don't work for them. If you, if as a self-employed person, you're contracted to do something and someone orders you to do it in a certain way, it's likely you're not actually self-employed, you're a disguised employee. And the reason I've started to mention this is, this has ramifications for you as a truly self-employed person. So for example, when I do work on a self-employed basis, none of my clients have any right to dictate to me how and where I do the work. So I agree with them a deadline for the deliverables, but the how and the when is down to me. If I went to take on some self-employment work, and we will go through some examples, and they said, well, you had to come to this office and you had to do it in this way, and you'll be responsible to this person as your manager, I'd just say, no, that's not self-employment. Now, you might want to take that as a job, but you have to be really careful. And the reason you have to be careful as well is the problem with the disguised self-employment, it carries all of the risks of self-employment, but none of the true rewards. Because one of the true rewards of self-employment is autonomy. You get to decide who you work for, you get to decide how you do things, and you get to decide when and how you're going to do it. Plus, if you do it in the right way, it can be quite lucrative. Disguised self-employment provides none of those benefits, and in fact, you'll potentially find yourself in all sorts of problems, because if your business fell to pieces, you would be not entitled to any benefits because your previous employer would say, oh, no, they were self-employed. And as we go through the scenarios, you'll see some examples of where this has happened to people. all of the scenarios we're going to talk through are real scenarios. They're not made up. These are real scenarios, okay? So I'd like to present you with a scenario. These, as I said, all real. I've been working with a client for several months and have yet to receive a single payment from them. I'm constantly getting a different excuse as to why payment can't be made, and I'm running out of patience. When I started the work, I issued a standard contract, but they were in a rush to begin the work, so asked me to begin while head office was reviewing the contract. I completely forgot about this and have since realized they never signed the contract at all. So just think about that scenario for a moment, and do put comments in the chat. What are your initial thoughts about that scenario? What are the initial red flags or potential problems where it's already gone wrong? What do you think? Will I drink toasted coconut coffee? What do you think? Anybody? What do you think has gone wrong? Remember, this person is right. It's like, right, okay. So Jennifer said they've got no legal standing to get their payments because it hasn't been signed. They started work before a contract was signed, right? So if you have, could be retrievable payment terms, but it might be better to walk away. The person was very naive. So you can actually, you can pursue payment without a contract. You may have an exchange of text messages. There may be some discussion verbally, but actually in this scenario, the first mistake that they've made is twofold. The contract, and we'll look at a contract, we'll look at the kind of contract I use, and you're welcome to a copy of it. The contract is useful for a number of different reasons. So many people first starting out, often when they get their first initial clients, they feel like if they try to get someone to sign a contract, they'll come across as aggressive and pushy. Nobody who you would work for to do a job, whether it's providing a product or service, would find it odd or strange for you to want them to sign a contract, because a contract actually protects them as well. The other reason that contracts are really important, besides getting paid, is that the contract specifies deliverables, or should specify deliverables. And one of the things I've often seen people first starting out, one of the biggest issues, the problems they have, is they don't really understand how much they should be charging for their work. And if you don't understand how much you should be charging for your work, you can end up in really bad situations where you are doing projects, tasks, but you cannot do them in a profitable way because you've agreed to do a project or a task with no real limits on what the client can ask for. So the other reason it's really important to think about contracts is not simply about the payment, but also things like the schedule of delivery. And that's the schedule at which you'll deliver work. The contract as well, it being signed, does make payment disputes much, much easier, because you've got something, if you need to take them, for example, to small claims court, it makes it much, much easier. In this scenario, this person potentially could get paid eventually, but they might have to take them to small claims court. The other reason it's really important to get people to sign contracts is it's very important that you have agreed not only the deliverables, i.e. what you're going to do for that individual, but the amount of things such as revisions. And what I mean by revisions is what's quite common for me is I might do some work for a client where they ask me to do some research and write a report for them. My contracts always specify the number of revisions I will do to the report. So what I always specify is I will deliver you the draft report by this date. You have X number of days to send me comments for changes, and then I will make those changes. But generally speaking, depending on the contract, I often always specify one revision cycle. The other reason this is really important is you can end up with what I call mission creep or scope creep. And a warning sign is clients who won't sign contracts, who are very vague in what they want. Because with no contract, they can effectively blackmail you to do more and more work, cutting your daily rate or your overall rate, because they can say, yes, but it's not quite finished. If you could just add this, or if you could just do that. And also a very common tactic by some unscrupulous customers is to say, I don't actually think the work is worth this. So instead of paying you the £3,000 we agreed, I'm going to give you £1,000. Getting clearly defined contracts, clearly defined schedules of deliverables is a really good common way to avoid this. Okay. Let's think about a slightly more complicated scenario. Okay. I was contacted. These are all real, by the way. They're not made up. I was contacted on a freelance website by the CEO of a telecommunications company. They said they were looking for an in-house freelance designer. How you would be in-house, i.e. work for the company and freelance at the same time, I don't know, who would be able to work around a week a month and be paid on a monthly basis. We agreed to me working with them on a test client, creating a range of social media assets. They would need to assess the success of these assets and whether I would ever be taken on as a permanent employee. No contract was drawn up, so we've got the contract problem we've already talked about. We agreed to everything verbally via Zoom call and via email. I got added to their online work tracking platform and worked with them for 6 days, creating all the assets and sending them over. The day after I sent in all the work, I got a message from the CEO saying, thanks, I'll get back to you tomorrow. It's now been 14 days with no response, and I have since sent 3 messages asking for an update, as well as my invoice for the 6 days of work I did, which amounts to £1,200. My day rate is £200, which they agreed to over email. Thoughts? What do we think about this scenario? What do we think? They've been tricked. Crystal, you're right. They have been tricked. We'll come to how they've been tricked in a minute because it's a quite common way of doing things. Anyone else think of anything else that's gone on? Yes, the email agreement does put them in a slightly better scenario. Yes, they could legally pursue the company because they have got, I have never seen emails, but they do have some emails agreeing to some rates. It's probably very vague about, what they would do for the work, but they are providing some, they have got some emails. So there's a couple of different things I would say about this scenario that caught my eye. And again, these are all real, right? So the first one in here, I think I'm drawing this okay. We agreed for me to work with them on a test client, creating a range of social media assets, okay? Depending on what you're doing, what your business idea is, many of you are going to be doing kind of service ideas where you may, for example, be involved in media, you may be providing expertise. Always be very, very wary about organizations that approach you and claim that they want you to create resources as a test. This is actually a quite common scam. And there's a large organization that I won't name for legal reasons who's notorious for this, who are a company, a trendy company that make various lagers. and they're absolutely notorious for approaching people and saying, why don't you create a brand for a new lager that we're going to launch as a test? And then what happens is they get the people to sign over the material they've created, and then they use it for free. I've never ever worked with clients where they have paid me to create things for test, not real clients. It never ever happens. If anyone ever approaches you about test clients, generally speaking, they're looking to get free work out of you. The second red herring in here that I would be really worried about is, I'm just going to change the color. If you are self-employed and you want to be self-employed, another common trick is for unscrupulous people to suggest that if you work for them on a self-employed basis, there is a permanent role down further down the road. But this doesn't make any sense on any level, because if you want to be truly self-employed, then you don't want to be taken on as a permanent employee. You want to work with clients, right? And so it's not something you're interested in. So be very, very wary of people who say, oh, let's do this, and then later on maybe potentially take you on as a permanent employee. Every time I've dealt with people just setting up in business where this has happened, they never get taken on as permanent employees. What often happens with legitimate companies is that if you've worked for them for a while and done a number of jobs, which they paid you for, then often they will eventually say, do you know what, why don't you come and work for us? And that does happen. But a company that you've never worked for saying, well, let's see if these assets that you've done or this work, then we'll take you permanent employee, it's always a red flag to me. The contract one we talked about a bit already. We've agreed to everything verbally via Zoom call and via email. This is always, again, a red flag. So my tip on this is, even in the early negotiation stages, if you're negotiating with someone about a potential contract, every single time you have a meeting with them, always email them to say, oh, following our meeting, I think this is what we're agreeing to do. Is this correct? You always want to be able to create a trail in case something goes wrong. This person was a bit smarter than in the first case because they have got some communication via email. So if they needed to take them to small claims court to get the money back, or to get them to pay, it would be easier because they have them. Well, that's an interesting one. Where did recording of Zoom calls stand in terms of legality? This is an interesting one. Now, remember, I'm not giving legal advice, okay? So this is a practitioner's take on this. In the United Kingdom, it is perfectly legal for you to record calls that you make, both on Zoom and phone calls, without the permission of other people. That's perfectly legal. Where it gets a bit trickier is if you took someone to court, such as small claims court, they might not want the call, but they would allow you to introduce a transcript from the call. So you could say quite legitimately, oh, I recorded this call and this was what was actually said. So in the United Kingdom, it is legal for one person to record a call without telling the other person. This is not the same in some other countries. If you are located overseas and attending this session, please check your local legal standards, because in some countries it is illegal. It is not in the United Kingdom. However, having said that, what I tend to do, because Zoom anyway, Zoom will pop up and say it's been recorded. What I'll often say to someone is, when I'm discussing, do you mind that I record the call? Simply because I can concentrate on what you're saying rather than taking notes. And again, most people, unless they're up to something quite shady, are absolutely fine on this. The other thing I'd say about this, which is not actually about going wrong, but something to be aware of in your planning, is they do talk about in here that they've messaged them and it's now been 14 days with no response. Something to be aware of as a small business and to build into your cash flow It's not a sign of something going wrong, but many companies are incredibly slow to pay, okay? And so you generally have to nudge people a number of different times to get them to pay. This is not a promotion for this, by the way, but just something for some of you to consider. There are a number of really good and quite cheap for self-employed people products that you can use to track cash flow and invoice people. I use personally, this is not an endorsement, but just so you know, I use personally a product called QuickBooks from Sage. And in Sage, in QuickBooks, I can record all of my expenses that I've spent on a project, and I can invoice my clients directly from the app. And it's really nice because it keeps a track of the money that I've spent on jobs, so my expenses, and my invoices are in there. And what's really nice about it as well is that if you, for example, travel as a self-employed person, your mileage is a tax deductible thing. So you can claim the cost of mileage. And QuickBooks is really nice because it will auto track your mileage. Because at the end of the year, remember, you'll do a tax return. Another really popular one is Xero. So you can just use a spreadsheet, by the way, but I do use QuickBooks, and it's really nice because I can use it to auto send reminders. But the point is, don't worry if people are paying you slowly to start with. That's not actually that odd. It's simply it's not that odd. It's simply that people are very slow to pay. In the United Kingdom, although you have to be careful about how to use it, if you're a small business and people go over, I think it's 45 days, you can actually charge them interest. The only thing about charging them interest is potentially they'll never employ you again. And a standard kind of rule of thumb is you can spend a third of your time as a self-employed person trying to get business, a third of your time trying to do the work, and a third of your time trying to get paid. And we'll look at a contract actually in a moment. Here's a third one, okay, which takes us into a slightly different area. And this might be applicable to quite a few of you. I'm a video editor and work for a media company on a freelance basis, and they make videos for other companies and individuals. I'm not employed by them, but I do have a contract agreement regarding the videos for them. Good stuff. So they've got a contract. Part of the agreement is as follows. Videographer acknowledges and agrees that the video and all rights included belong to and shall be the sole and exclusive property of video company. I've been asked to use a piece of music for a video that is definitely copyrighted. I've notified video company of the need to secure the rights to use this song for the video, and they have shared this information with their client. Okay, so just to summarize what's going on there, they're a self-employed video editor. They work for a company that we're going to call Video Company, and the agreement they have with Video Company, which is very common, is the work that they create for Video Company belongs to them. And so it's quite common when you do a project for a client that at the end they own all of the things that are created. The problem this individual has is they have asked him or her to use copyright material in creating the video. So what do you think? Is that a good thing, a bad thing, just not something to worry about? What do you think? Should you just do it? I'll just do it, it'll be fine. You think it's up to the video company to secure the rights? Could be. Anybody else? The videographer can't sign off other copyright material? Could be. Anybody else got any thoughts? You think it's good that it's been raised, right? Okay, so here's the legal take on it, and then I'll tell you the practical take on it. Something we'll talk about a bit later is the idea of he should go ahead with signing it. Okay. A really useful concept to get your head around when you set up and run your own company is the concept of liability that we're going to talk about. So when we run our own businesses, we enter a state of what's called liability. And liability is we are legally responsible for some things and not others. And we can use our contracts to try and control what we are legally liable for and what we're not. There are certain things, as you'll see a bit later, we cannot exclude liability for. You can't write into a contract to get rid of. And we'll see later what they are. In this case, if this contractor did as indicated, they would actually infringe on the copyright of the owners of the music. The fact that the company they're working for, the client has instructed them to do so, would make them both liable. They'd both be jointly in what we call severely liable. They'd both be legally responsible for using that without permission. In reality, what would actually normally happen is they would sue the company that he's contracted for. They wouldn't generally go after him, but it could happen legally. And so the other way that things often can go wrong, you have to be really, really clear about using other people's intellectual property. So some of you may have businesses where you do research for people, and you have to be clear that you do not make use of, without permission, proprietary or copyright material that does not belong to you. Because not only do you create liability for yourself, you can potentially create it for the client. If the client wants this to happen, then it's tough to do, but generally what you should do is push and say no, because this would create legal liability for us. However, if you feel really pressured and you do it, you do need a series of emails to make it clear that the client should be aware that this could create legal liability for them. A very common one, if any of you are interested in set up as web designers or similar or anything creative, is a client will come to you and say, I'd like this website. And they literally mean they want you to rip off someone else's website. This is very legally dubious territory to get into. And so what you need to suggest to them is, I can do you a website or a product similar to this, but I can't do one exactly the same. For those of you who may be interested in doing companies with goods and services in exactly the same way, you have to be very careful that you don't engage in what's called passing off. And passing off is when you make your product and service so similar to an existing one that it could create confusion, because you could be sued. And the thing about being sued as a small business owner is, if you get sued by a large company, it doesn't actually matter if they win or not. They can often bankrupt you due to the legal fees. And it's a tricky issue. And if you want an example of something that's passing off, but not, Colin the Caterpillar, yes. If you want an example of something that's just different enough to not pass off, if you go to Aldi has its own range of chocolate bars that are very clearly similar to other chocolate bars, but different enough so that they can't be sued. So for example, you're all potentially familiar with the penguin bar. Aldi has the seal bar. I love seal bars. They're penguins under a different name. So you have to think about, don't be involved in passing off. A very common business idea that comes through launch is people will say, I'm going to sell t-shirts or sweaters, and I'm going to put branded logos on them, or I'm going to sell football tops. And I'm going to use the Liverpool Football Club logo on them or the Manchester United logo. That can get you sued into oblivion really quickly and is to be avoided. Colin the Caterpillar is a good example. Marks and Spencer's is taking legal action because various people are doing it. If you're a big company, this kind of thing can be the cost of business. If you are a small company, this can bankrupt you. This can send your company under, or if you're a sole trader, could legally make you personally liable and could bankrupt you. So don't do it. Let's have a look at another scenario, right? Because this is a very common one as well. The individual in this scenario has agreed to do a project for a large multinational telecommunications company. The work involves some site visits and then writing a report indicating how well spent some EU monies were spent. The large multinational company needs the report in 12 weeks to fulfill a contract they have with the EU. The contract was signed in advance. As the project progressed, the client starts emailing contractors saying the work is crap and they're going to sue the contractor, pointing out the contract says if they're unhappy, not only will the contractor not be paid, he will cover the cost of someone else doing it. This is actually me, right? This is a contract I got involved in a few years ago for a large multinational telecommunications company. They approached me and said, we need you to write a report. Well-known character silhouettes you can sort of get away with. Depends. What they might do, Lee, is they might still sue you even if they haven't got a really good case, on the basis that threatening to sue you normally frightens off small businesses, but you can sort of get away with it. In this scenario, I'd agreed to do this work. We'd signed the contract, so the contract's all straightforward. But truthfully, I hadn't read them properly. And I realized halfway through the contract that it said if they rejected my work, not only would they not pay me, I would have to pay for someone else to do the work. And because they needed to deliver it in 12 weeks, I potentially would have to pay someone a significant amount of money for them to be able to do it in, say, 6 weeks. And when we first started the work, they were very happy. But as we progressed, they kept sending me more and more emails saying the work was crap. They were going to sue me. It was rubbish. Their lawyers were going to take me to court. And so on and so on. So what did I do? Or what would you do in that scenario? So the client's unhappy, and not only are they not going to pay you, they're going to sue you. What would you do? This is quite common, by the way, where you get subcontracted as part of a bigger project. It happens quite often. Right, refer back to the schedule. Was the quality of the deliverables subjective? Yes, it was, Robert, which is I pointed out to them. I pointed out that actually it just specified that they just specified that there was a deliverable and they had the right to review it. Anything else that you would do? Shall I tell you what I actually did? So, yeah, I put together a remediation plan. So what I did was, first of all, I asked them what their concerns were and if they could bullet point them so that I could take care of them in the next draft. And so, yeah, we didn't call it a remediation plan, but that's effectively what it was. So there was that side of it. But then there was another side to this that I hadn't originally considered, and something for you to consider when you are working for clients. Often, when you work for clients, the things that you create for them, they need on a time scale. And the reason that they need them on a time scale is what you're doing for them is part of a bigger project. And so it occurred to me to investigate further what would happen if they didn't have my report in 12 weeks. And it emerged that if they didn't have my report in 12 weeks, they would themselves default on a contract they had with the EU, and the EU would not pay them, right? So I realized actually this gave me leverage, and I could negotiate with them and say, look, you actually need this report. So let's work together to sort this out and get the report in. And so I made the edits to the report, but they continued to be in touch to say, we're still not very happy, and you need to give us a discount. And it became apparent to me that actually they were not particularly unhappy with the report. They were happy with the report. They just wanted a discount. And this was a way of threatening me to get me to give them a discount. And in the end, I did give them a discount on the work of a princely sum of £100, right? And this was a contract for tens of thousands of pounds. And it turned out that the way their organization operated, they expected all contracts, once they were signed, for the people who were involved in them to try and get a discount. And as soon as I gave them their £100 discount, they went away. The next thing that happened was I was sat at home one day talking to my wife, and I said to her, I've sent them the contract, but I've never ever heard back. I've sent them the report, but they haven't responded to me. And I'm really nervous that later they could come and sue me. And suddenly I had a brainwave. And part of the contract that I'd signed with them said that the report was to be published on a website. And publishing it on this website that they owned was to fulfill part of their contract with the EU, to say we had an independent report, then we had it published. And I checked the website and they had stuck my report on it. From my perspective, this was fantastic. And the reason it was fantastic was no longer could they come back to me and say the work was substandard, because the very act of putting it on their website to fulfill their contract with the EU meant that they couldn't say to me it was substandard, because I could say, but why have you given it to the EU if it's substandard? And the whole thing went away. 2 weeks later, they paid me. They never spoke to me again. They never dealt with me again, but they paid me with no problems. And the reason I put this example in of myself, one thing that you might get very, very nervous about when you first start is your clients can be quite aggressive. And they can be quite aggressive in both terms of trying to get discounts and trying to increase the amount of work that you have agreed to do for the money provided. And when you first start out, this can be really, really tricky, because A, you want to make sure your clients are happy. And if your clients are happy, by the way, always get a testimonial off the client. Whether you're providing a product for them or a service, one of the most powerful things you can do as a business owner when you first start up is get your clients to write you a short testimonial. And even better, a short testimonial that you can use on LinkedIn or on your own website to say, I'm client X, I worked with this company or this individual and they did this for me, I was super happy, they're really great, you should work with them too. Because when you first start out and you haven't got a reputation and you don't have networks, testimonials from other companies are a really powerful way to draw in business. So, but when you're doing the work, many clients who are actually very happy at the end can be super aggressive, and you can feel like at times it's all going wrong when it's actually not. And so it can be handy to sometimes just take a step back and say, is the client truly unhappy, or is this a negotiating strategy? When you first start out, it can be tricky to tell the difference. When you've done this for a while, like I have, you start to realize the difference. So let's have a look. Let's have a look at a fairly standard contract of the type that I use, okay? Hopefully this will pop up. So let's talk about my previous advice. My previous advice is, if at all possible, never ever start any work without a contract, okay? Now, some of you might be involved in doing small media jobs as a side hustle. And what I mean by a side hustle is it's something you do as a kind of almost like a hobby to earn a little bit of extra cash. And it's all kind of done verbally, and it's all done for cash. and potentially you don't declare the money to the Inland Revenue. Okay. Now, I'm not going to judge you on that. I'm obliged, I guess, to say that's illegal. But if you are actually truly serious about doing this as a business, then you need to start thinking about being professional. And actually, providing the client with a contract is a professional way to do it. So, there are a number of sites that provide standard contracts that you can tailor to yourself. Okay, this is not a recommendation. I'm just going to mention this as an example. So there is a site in the United Kingdom called Law Depot, and Law Depot has a free trial of a week. And when you use Law Depot, it's got like, it asks you a series of questions about the contract you're trying to create. And when you answer them, it creates you a standard contract. Now, in an ideal world, if you could afford a lawyer, that'd be great. You get a lawyer to draw up your contracts. When you're first starting out, it's unlikely, though, you can afford that. So something like Law Depot, which is LAWDEPOT, is quite handy to draw up relatively simple contracts. So a good contract has some of the following elements. Okay, it's really clear who the client is. Be very wary of organizations who contract you to do something and then try and suggest that the actual client is a different company that they own. Always be really clear about who the client is. This is a made-up one here called Bigco. This contract is also really clear about who they are contracting with. Now, in this example, I've done it on a self-employed basis. Some of you might be setting up companies. If you're setting up companies, limited companies, the contractor would be the limited company, okay? Always be really clear. I've kept this quite vague, and you can make this as specific as you like. Always be really clear about what you are actually providing to them. I could have made this longer. I could have put consultancy, preparation, and writing of market research report. This is a simple example for us to talk about. You don't have to have this. It is sometimes handy, though, to have a break clause. And the break clause is the notice which each party needs to give to void the contract. You can also build in there fees for early release from a contract, okay? When you first start out, just having a nice simple contract, though, is really helpful. So if we go to the second page, the critical thing not to miss is it should be absolutely clear what the client is paying for, right? So here in this example, the client is paying a flat fee of £30,000 for the services. I've also got in this contract, which it's up to you if you want to put in or not, that they pay a retainer, i.e. they pay a retainer or 10% at the start of the contract, because depending on what you're going to do for your clients, you may need some money up front. Then, depending on what kind of work you're doing on the product, I also then have staged payments of 25% across 4 stages: project stage 1, 2, 3, and 4. So they pay me at different stages. You don't have to do this, and some companies will only agree to pay you at the end. It's up to you. Depending on the value of the contract, it's up to you if you want that kind of clause or not. But you always absolutely are clear about how much they pay and what they're paying. If you go down the flat fee basis, you need to be really clear that you can make money off that contract. So £30,000 sounds like a lot of money. And if you're starting off, it is. But if I've done my sums right, it could be that the work that they need doing might cost me £35,000 to do. And in that case, it would cost me £5,000 to do the work, right? You also need to be really clear, and this is getting a bit more complicated. Does the payment include VAT or not? Loads and loads of independent contractors get caught out on this basis. I'm not a tax expert, so I'm not going to go into this in great detail, but always be clear if it includes VAT or not. Because otherwise, what you can end up doing is submitting a bill and say it's £30,000 plus VAT at, what is the current? 20%, which would take you to 36,000. But they say, oh no, we agree to 30,000. You did not specify that fee did not include VAT. That is actually a mistake that can crash your business right at the start. Also, depending on the kind of project you do, whether it's a service or a business, it's up to you and the client to agree if any of the expenses that you're charging, i.e. if you need to travel, if you need to buy materials, are they included in the flat fee or are they additional? On some of my contracts are included in the flat fee. On others, I charge them at, say, £100 a day. And that covers things like food, travel, and so on, okay? Late payment, I charge at 8%, which is known as the statutory rate. So if they don't pay me, I can charge them. I've never actually had to do it. I've occasionally had to nudge people. I've had to nudge people about payment, but I've never actually had to charge them interest. This next one, from a contractual point of view, is also really important, right? When you work for clients, your clients need assurances that materials and information that they provide to you is confidential and that you won't disclose their private information to other people. An absolutely surefire way for it to go wrong and to get sued is to provide confidential information to somebody else. And here's a very common scenario in which this can happen. You have a potential client and they've seen on your website that you've worked for one of their competitors in the past. You've done some work for a competitor. And they say to you, oh, in order to look at the quality of your work, could you send us the report that you wrote for that client? Under no circumstances, unless it's publicly available from the client, never send work that you've done for one client to another, right? That is an absolutely surefire way to be sued. What you can send them is, let's say you do work where, I don't know, you've designed a website or a logo that the client uses. Absolutely, you can point the prospective customer to that work and you can point them towards testimonials. But don't ever send new clients work you've done for existing clients. You will be sued. Don't be sued. It's not pleasant, right? We had earlier an intellectual property scenario. You should always be really clear up front who owns the work that you create. Many of your clients expect that they own what you create. So you have to be really careful that if you invent a process of doing something or you have a certain workflow, you don't actually sign it over to your client so you can't use it again. And so your clients will want to see that there's intellectual thingy. You also need to be really clear, because some clients don't understand this. You are not their employee, right? If your client starts to behave as if you're an employee, you need to put them straight in a polite way. You are contracted for services. You are not an employee. You don't work for them. They've contracted you to deliver a service. And lots of fake self-employment, tries to disguise this. And a really good sign that you're not involved in disguised fake self-employment is that all of my contracts have a right of substitution in them. So they've contracted with me that I will deliver something. What they haven't contracted with me for is that I will do literally every element myself. Some of the work that I do for clients, I actually hire other self-employed people to do. And I pay them as a third-party subcontractor to me. They don't have a direct relationship with the client. It's with me, right? I always have the right of substitution. If you set up a business and there is no right of substitution, you can get yourself into deep water because you might need someone else's expertise at a certain point. So always make sure there's a right of substitution. And the other thing I always have in my contracts is autonomy. You're paying me for my expertise and to deliver something. I do it in the way that I think is best. You don't get to tell me how to do that. We might have a discussion about it, but I'm not directly controlled by the client, right? Another warning sign that you're getting involved in fake self-employment is if they want exclusivity. If they want exclusivity, often it's fake self-employment. And a really good sign of fake self-employment is they'll say you need to make yourself available for work between 9 and 5 on these days. That's fake self-employment. They're just trying to hide the fact that you're their employee. And so I'd never get involved in anything where they'd say, well, you need to come and do this at these points. I'm like, no, that's just not what I do. You cannot limit my ability to take on other work. I'm not at your beck and call. And then there's some standard things here about indemnity, which I'll come on in a minute. There's some other stuff in here which is standard legal wording that I can't sign over. There's some other stuff which is on standard contracts. Yeah, so EFL teaching and stuff like that, stuff like delivery drivers. It's a whole, I don't want to get into it too much, but it's a whole maze of disguised employment. And to me, the benefit of being self-employed is you have control. If you don't have that control, you'd be better off as an employee, because as an employee, you'd get paid holidays and sick pay. You'd get pension, generally. You'd be enrolled in a pension. Fake self-employment is a way just to cut businesses' costs. One of the ways, I'll tell you another way to spot fake self-employment. If you ever get a contract that pays minimum wage, i.e., it pays a sum equivalent to minimum wage, it's not really proper self-employment in my eyes, because what you're actually doing is you're doing the work of an employee on minimum wage. The construction industry, for example, is notorious for this. One of the biggest areas of self-employment in the United Kingdom is manual labourer. And these people are working for minimum wage, but it's disguised as a contract. They have no pension, they have no sick rights, they have no employment rights. And the problem with that is, if you do self-employment, you want to get to a point where you can take breaks, or there is scope for you to be sick or unwell. Those kind of fake self-employment, there's just no scope for it because you just don't earn enough, right? And a phrase that a friend of mine uses for his self-employment, and he's been doing it for a number of years, is he's reassuringly expensive. And that's what he always says to the client. So they'll occasionally say to him, you're quite expensive. And he says, yes, I'm reassuringly expensive. Because I'm not actually going to cover it too much in this session. Many people, when they first start out on self-employment, do contracts too cheaply to win a contract. It's a dead end. What happens is, if you do contracts too cheaply, you get all of the stress and none of the benefit. I do my external work my contractual work because it's lucrative and it makes money for me, right? And I enjoy it actually as well. I wouldn't do it if I couldn't make decent money at it. I just do stuff as an employee. And if you do find that you're not making money at this, either you need to raise your rates or you're trying to be involved in self-employment in an area where, frankly, it's just not worth doing, right? So a final, I know this is listed as 2 hours. I've got no idea why. I don't need 2 hours for this. Something I just want to mention to all of you, tied to the things I've mentioned before, which is, I'm just going to go back to my slides. I've never ever done a single bit of private consultancy without public liability insurance. I've never done any consultancy without it. So you remember earlier I mentioned about this concept of liability. So liability are things that you are legally responsible about, right? I can totally understand when you first start, you might think insurance is too expensive. However, public liability insurance, for me, is such a thing. It is so dangerous not to not have. My public liability insurance, and this is not a promo for them, but just so you know, my public liability insurance is from Hiscox, which is a very reputable firm. It costs me £18 a month. It's also a deductible, so I can deduct it from my profits, and it covers me for public liability and in professional indemnity. Even if you cannot afford any other insurance, if you're serious about this, do not trade without public liability insurance, right? This is the reason why. I'll give you a very common scenario. You go to a client's site to talk to the client about something. And this sounds like a wild scenario, but it happens. While you're going into the client's site, you accidentally bump someone and they fall down the stairs and they break their leg. You might say, well, that's an accident. And it is. But because you're operating in the course of a business, the insurer that insures that company, or if they're a private individual, their house insurance, may say, our client has incurred these costs. You are liable because you caused the accident. And without getting too complicated, this could end up in court. My public liability insurance covers me so that when I am interacting with the public and suppliers, it covers me for any claims made against me for those kind of things, right? Public liability insurance, honestly, don't operate without it. I know someone who caused a serious accident on a client site, and they were bankrupted because they had no public liability insurance. They were sued for hundreds of thousands of pounds. And if they'd have paid the £18 a month their public liability insurance, it would have covered it. The second thing tied to this is if your business involves moving equipment around, i.e., if you're doing something with cameras and so on, you might want to look at contents and portable equipment insurance. This is because, let's say, you are a company that films things. If your gear is stolen or trashed on site, what's the plan? Because if you've got a contract with a client and you're going to deliver on a certain date, and you've got £5,000 worth of camera gear and it gets stolen, what exactly would your plan be? If you went to the company and said, unfortunately, my gear's been stolen and I can't no longer fulfill the contract, they would just say, that's not our problem. That's your problem. We've contracted you to do this and you better deliver. They wouldn't say, oh, well, never mind. I know we paid you for some of it, but you know, these things happen. No, they just say, that's not our problem. You need to do it. So if your work involves contents and portable equipment, then do look at the insurance for that. Because honestly, again, the amount of businesses I've seen clobbered because their van gets stolen with all of their gear and they do not have the right insurance, it's horrific. And then the final one, which I also have, but you might not need, is professional indemnity insurance. And so this covers me if I make a mistake, or if if my clients suffer financial loss as a result of some of my work. I'm covered up to £150,000, and that's because I tend to do contracts in the tens of thousands. I don't go into the hundreds of thousands. Many, by the way, many reputable companies, most actually, will require to see your public liability insurance certificate and your professional indemnity insurance certificate before they will sign your contract. So you could think about dodging some of these, but honestly, of all the things that you spend money on, these are not the ones to skimp on, right? It's just not worth it, because well, not the best feeling in the world, but a good feeling in the world is if something goes wrong and you injure someone, that you have a phone number to ring and there are professionals on the other side of the phone who say, yes, Dr. Knight, that's what you pay your fees for, right? In my early years, I did it without this insurance. And in the telecommunications example I mentioned, if the client was unhappy, my professional indemnity insurance would have helped cover it. But because I was naive and didn't have it, I was on my own. They could have come after me for tens of thousands of pounds. Now, thankfully, they didn't. So to summarize, because this doesn't need 2 hours, to summarize, don't really, if you can avoid it, do anything without a contract. Be really clear and specific about what's in the contract. Be really clear and specific about deliverables. And by the way, you can take from this chat, from the file section, the contract I put up, if any of you want to use it as a basis for your own contracts. But the critical thing, I think, across all of the different points I've made this afternoon is, if things are starting to go wrong, or you think they're going wrong, don't bury your head in the sand. Go and talk to the client, right? Go and talk to the client, say, look, how can we make this right? Because most clients actually just want their deliverable. And I'll be honest, most times, I found most of my clients to be absolutely reasonable. Clients who refuse to sign contracts, clients who refuse to write anything down, clients who are really vague about deliverables, clients who are really vague about what they want to pay, clients who promise one figure and claim there'll be a bonus later. These are all red flags to be avoided. Good clients don't mind signing contracts. Any client who says, I don't want to sign a contract, or what do we need a contract for, is likely either an amateur themselves or they're a crook, to be honest, and they're likely to try and get out of paying you. So don't do it. Oh. Any questions? I'm really, in this session, I'm just trying to cover a few core points. I'm not trying to cover literally everything. Any questions? I think you can put your hands up if anyone wants to ask me a kind of verbal question, and I can no? Any questions for the chat? Anybody got any questions for the chat? So you can, on the subject of nudging payment, better to charge 8%. So you'll have to excuse me, I can't remember the act, but basically there was an act passed a couple of years ago that allowed small businesses to charge for late payment, and it's called the statutory interest rate. And currently the statutory interest rate is 8%. You can charge a flat penalty fee. For reasons I won't bore you with, avoid using the word penalty and call it an additional charge, right? I'll bore you with the reason why. Try and avoid the use of the word penalty. Penalty has a particular legal meaning which is difficult for private individuals to enforce in court. Use the term additional fee or additional charge. Don't use the word penalty. Any other questions? There is a long explanation about why not to use penalties that I won't get into. Oh, I can see a hand up. Let's see if I can unmute. You should, I've made you a presenter, so you should now be able to, oh, sorry, I muted you by accident. Oh, sorry, I'm not used to.
Hello.
Oh, hello, hi, sorry, I muted you by accident.
Yeah, that's all right. Yeah, so like going from everything you said, I was trying to think about it from a perspective of a business that operates a subscription model. So when it comes to the things like the VAT, I don't know if VAT covers subscription based services. Sorry, I can't hear you.
Myself. So let's say your business is subscription based. The first thing you need to determine is if it's a subscription that you're offering to consumers or other businesses. If it's a subscription service you offer to consumers,
It's to
consumers
other
have,
business.
right, okay, this makes it easier. If you offer services to consumers, they
Yeah.
have all sorts of additional statutory rights, okay? If you offer subscription services to other businesses, it's a business to business contract and they don't have these additional extra rights I won't get into. So really it then comes on, it's really about what you want to put in your contract about the subscription. But what you would likely do is specify minimum length. You'd likely specify length of notice to cancel. You'd likely specify a period where they could cancel early in the contract, and you might give them break points at which they could potentially cancel a contract partway through a year, but for
Mhm.
50% of the cost. And really, it's just up to you what you want to write into the contract. When you get onto subscriptions with other companies, there are various templates you can find about subscriptions, but you need to be clear about what does a subscription cover and what doesn't it cover. So for example, your subscription may be that it provides a service but it does not provide any support, right? So they have
Mhm.
access to a service but you don't provide any support. You also potentially don't specify any service level. What I mean by that is you don't specify the percentage of time the service will be available. With that kind of thing, subscription, it is actually worth potentially taking some legal advice.
Okay.
No problem. Any other
S-
questions? Oh,
Thank you very
sorry, go on.
much.
No problem.
Just one more question.
Yeah, go on.
When it comes to professional liability,
Yeah,
so let's say you have a subscription service that gives businesses access to some information that um yeah, let's say you give them access to some information and some other things, and then
yeah.
does it, like, like, is there any kind of professional liability if something goes wrong on their side?
So
um
basically, your professional liability covers you if you do something wrong. What you'd need to write into your contract was to specify the usage that they could make of that information. So if you've got a subscription service which is about giving them access to information, then you would specify that they can't take and reuse that information and provide it to other people. What you don't want is to provide a subscription service where one people could subscribe and then provide that information to other people,
yeah.
right? What's worth looking at is go and have a look at the terms and conditions of some sites that provide professional subscriptions and have a look at
Yeah,
their terms and conditions as a starting place.
yeah, that makes a lot of sense. Thank you.
Okay. Any other questions before I wrap up? No? Well, hopefully this has been of some use, because I try to make these kind of very practically focused. This is not theoretical because I've had these problems. Do feel free to contact me if any of you want to talk a bit more about this. My email address, I'm just going to put in the chat. Do feel free to drop me an email if any of you want to talk any further about this. But it was lovely to meet you all. I'm going to stop the recording at that point, which